May I please, your lordships? My lord, I have mentioned item number 44, 45, and 46, my lord. My lord, it's a bunch of four readable, my lord. However, read, uh, readable number 30 of 2022 has not been listed today, my lord. So I've read that the matter may be listed after the vacation along with the
Who is the
readable
government
30.
state council?
Lordship, yes.
This I ask for continuation of delay.
Yes, your lordship.
In any case, the Supreme Court order is there,
Yes, your lordship.
which covers your delay.
Yes.
So we can dispose this.
Okay, lordship,
ma'am.
if that is
I-
the case, yes.
Yes, ma'am.
With appeal will constitute some other
Lordship,
day, but
lordship.
we can condone the delay.
Oh, lordship,
Yes,
we have
lordship.
the,
Okay, lordship.
to wait for some time.
Lordship.
May I please, your lordships? Your lordship, I beg to mention item number 47.
Let it come up before some other bench without me.
Yes, your lordship.
List this case before any other bench without one of us. Within bracket, put my name.
Also, your lordship, item number 42 is fixed today. But as on the last occasion, this honorable court has made it clear that you are unable to pass order since the matter is pending before the Supreme Court, lordship. So, if this...
We'll have it after the winter vacation.
Yes, your lordship.
It appears all your prayers will be answered.
Yes, your lordship. So I have both the letters order passed on 9th of December. So if this can be put a place on record, lordship. My humble prayer is, lordships, that if you would kindly record the directions in the order, lordship.
Must need to call that. Then counsel for the petitioners furnished an order dated 9/12/2022, passed by the Honorable Supreme Court in IA number 144787 of 2022 and 144785 of 2022 in WBC number 310/1996. The same is placed on the court. List the matter after the winter vacation.
Lordship.
For motion, item number 1.
The Lordship, before my senior, the amicus makes a submission, I want to put forth two facts. Today morning, Your Lordship, if Your Lordship recollect, on 28/9/2022, your my lords had passed an order where, looking into all the facts at the chronology of events, the assurances given by Oasis, Your Lordship was compelled to liquidify the particular amount of money, 10% as per the tender clause. Now, against that, after that, what happened is that 28/9/2022, the order was passed. My Lord will kindly see order dated 12/10/2022 in the writ petition. My Lord is there, 12/10/2022.
Yes.
Your Lordship, Mr. K, we have perused the progress report filed by the authority engineer with regard to package 1, 2, and 3. As regards package 1 and 2, we see that some work has been done, but at a very minimal level. So far as package 3 is concerned, it appears that not much progress has been made due to the frequent rain. Further, it is stated that the newly appointed contractor is expected to continue their works till new arrangements are made. At this stage, Mr. K.P. Pathak, Learned Senior Counsel, assisted by Mr. M. Arora, Learned Counsel for the respondent number 12, contractor for package 3, submits that the three directors of Mr. MS Oasis Techno Construction Limited could not appear before this court today as directed on 28/9/2022 due to health reasons. He also makes a proposal to have a deliberation with the authorities of NHIDCL with regard to package 3 in the presence of the learned amicus curiae. The proposal made by the learned senior counsel is accepted by as Burgoyne learned counsel for NHIDCL in the interest of the public. In view of the consensus, we directed the respondent number 12 and the NHIDCL to have a deliberation with respect to package 3 in the presence of learned amicus curiae. We also direct that the NHIDCL shall take the initiative for the deliberations. Now, Your Lordship will see, I am putting before Your Lordship these two filing reports of the Honorable Apex Court. Lordship will see at the top, the Lordship will see there's a diary number and it was filed on 10/10/2022 against the order of 28/9/2022, and the order was passed on 12/10/2022 on the same matter. It was a defect was also not been cured, but it was a mention was been done and they did the matter. Now, Your Lordship, why I'm putting this fact before Your Lordship today? On that very day when this matter was in session before this honorable court, when Mr. Pathak, representing Mr. or the Oasis, was giving a different picture than the senior counsel, we all appreciated it. Everyone was taken on board. But at the same very time, at the same very day, they were agitating the issue before the apex court as if they have been agreed with that order. So, what it shows is that the Oasis has not only broke the trust of this institution, but later it played with the trust of this institution. They should have not done what they have done. They should have brought to the knowledge of this court that, my lord, we have filed an SLP, let this matter not be taken. So two instructions have been given to two senior lawyers. And being an officers of the court, not, for example, I'm not an NHIDCL or anyone, being an officer of the is a highly contemptuous act they have done.
May I please, Your Lordships? Lordship, I have been instructed to appear on behalf, as a proxy counsel, to appear on behalf of the applicant in the IA 203, Lordships. Lordship, I have been instructed that the NHIDCL has terminated the contract of the respondent number 12, Lordship. So, Lordship, if this matter can be adjourned, if opportunity may be given to the applicant to file additional affidavit on the, based on the facts and circumstances that has emerged, Lordship. Lordship, if I don't have the instruction, but if I may assist the court, Lordship, already the direction of the Supreme Court has been complied with. The amount has been deposited, Lordship. And also on the last date, Lordship, White order dated 8/12/2022, Lordship, the NHIDCL was instructed to file their affidavit, Lordship. And also on the amount that has been deposited. And Lordship, instruction was also given for the counsel for the applicant to make the position clear whether they will continue with the work, Lordship. But then, however, I'm not in a position to answer that, Lordship, because my instruction is only to pray for some time to file additional affidavit, Your Lordship.
My Lord, we recorded a submission of my learned friend, Mr. Guwahati. On 30/11/2022, His Lordship was sitting on that day.
Mr. Taka, just a minute.
Yes.
Before we forget, now that Mr. Guwahati has brought up this issue.
My Lord, on that aspect, I want to make a submission.
No, just listen to
Yes.
me so that you can submit better.
Yes.
Have you, Mr. Guwahati, you were directed to be the one who would coordinate to have the
Yes.
meeting?
We did it. We did it. We had the NSIDCL and all of us had a meeting where meeting was being presided by amicus curiae representative because there was a certain family, someone
My
passed
Lord,
away.
12/10 at para 12, I have noted that in the list of things.
And Mr. Pathak senior counsel Pathak also appeared on behalf of Oasis, and Mr. M. Arora appeared in that meeting. We all had discussion, but there was not a whisper that they have assigned this order before the Supreme Court. They have not brought this.
Yes.
They have hidden from us.
My Lord, on these issues, I want to make a submission. That's why, my Lord, before we go on to the other issue, I would like to make a little highlight on this point.
Just a minute.
Yes.
So, nothing, no decision,
No.
nothing.
My Lord, there was a bereavement in my family, so my junior appeared on my behalf. Now there was a deliberation, but there was no. It were miles apart, so no settlement. Accordingly, on 30/11/2022. Yes.
Yes, Mr.
So, my Lord, I'll highlight that aspect of the matter also. But we recorded a submission of my learned friend. My Lord, on 30/11/2022, when Honorable Justice Sartu and Justice Barra was in session of this court, there was few moments as a counsel where I become very angry and emotional. Because, Lordship, going by the orders, well, not 12/10/2022, a rosy picture was painted before this honorable court, and we said, okay, then the parents of the three characters were also excused that day. Lordship is well aware. And then we said, okay, we go for settlement. And everyone was happy. However, my Lord, going by that day itself, and the order was passed on 12/10/2022, the Honorable Supreme Court's order. So it is very obvious that filing of the petition, SLB, before the higher court, yes, which was filed on 10th, as per the record, that was totally suppressed from us. And
Now-
if before this honorable court, on 12/10/2022, it was the bounden duty of the Oasis to bring before this honorable court that they have filed a case as a petition before the Honorable Supreme Court on 10th of October. And in that view of the matter, my Lord, what you should have informed that during that pendency, the issue would have been decided. So, my Lord, in fact, on that day, I was making a submission. My Lord Justice Sartu will remember that very emotionally I was making a submission that it is a fit case to impose damage, compensation, cost. It was a fit case to impose cost. That was my submission that day, looking at this particular aspect of the matter. But honorable justices were very kind enough that day. So that is one aspect of the matter. The conduct of the respondent number 12, very, very unfortunate. And I didn't expect the manner in which it was pended. This court was taken for a right, if I may say so. I mean, of course, Lordship, with due respect to this honorable court. So that was one aspect of the matter. Then, my lord, on 2nd November, as directed, we participated in the deliberation, but even on that day, my lord, the filing of the SLP and all that, we were not aware. That was not an issue. So, my lord, they were trying to enjoy the best of both the worlds. So that aspect can be considered. And also, Lordship, on 8/12/2022, on the last hearing, by then the termination notice has been issued, if I remember correctly.
We have issued the termination.
By then the termination issue was already issued on 8/12/2022 when Mr. K.N. Chowdhury was appearing before this honorable court. So, my lord, the plea that to file an additional affidavit today to pray for time on the ground that the termination notice has been issued, my lord, this is not a valid reason, ground to give adjournment. And Lordship, at the convenience at the consent of the respondent's counsel, it was fixed today. In fact, he was insisting for 12. But since he was expressing it is not very sure for him because of pendency in the Supreme Court case, I plead on his instruction, it was fixed today. So, my lord, that aspect will be taken into consideration.
Lordships, if I may kindly pray before this honorable court, I'm just a proxy counsel, Lordship. And also, Lordship, if we look at the Supreme Court's direction, Lordship, the direction has already been complied with, and the amount has been deposited. And Lordship, also, the petitioners were given liberty to file applications. Lordships, the applicant was given a liberty to file application or affidavit. This is the direction of this honorable Supreme Court, Lordship. So accordingly, they have filed the IA, Lordship, and also they have also filed an additional affidavit, Lordship. Yes, your Lordships.
The application file is not as per a direction of the Supreme Court. All right?
Lordship, to that effect, affidavit was also filed.
Listen, the IA you filed is not as per the direction of the Supreme Court. That is why we adjourn.
Yes.
You were only asked to deposit the amount and then approach the court. But you kept asking us to review our order, directing you to deposit the amount.
Without
Right.
depositing the amount.
Without depositing the amount. So these things, now here we are,
We have taken note of all these developments.
Lordships.
The development that has taken place prior to this, before the Supreme Court, that we have taken note of. We have taken note that this IA was filed after the Supreme Court directed you to deposit the 10 lakhs. You did not deposit and filed the IA. After that only you deposited the amount.
Lordship, that was within the time frame
That
because
was whatever it is, you should have filed the IA after depositing the 10 lakhs.
10 crores.
Lordship,
10.2 crores.
as submitted,
I'm
as
sorry.
submitted earlier, Lordship, I'm just a proxy counsel. I'm not a counsel,
I
Lordship.
know. We are just giving a hint
Yes, your Lordship.
so that you can go back and tell your
client.
client or your senior counsel that the court is seized of all the matters and the actions that you're doing, plus misleading this court,
In fact,
plus the affidavits that you have filed earlier saying that you'll be completing this work by this
Yes.
time, this work by this time, there's so many affidavits.
You have met Mr. Tucker, you have given a copy of the note to Ms. Nitu.
I'll give Lordship. I'll
Give her a copy.
These are list of dates. List of dates.
List of dates, have you included all those affidavits, or have you stated that they'll be completing this thing?
My lord,
as well?
There are promises.
My lord, Lordship, in the order, if your Lordship, you kindly go through in that, I have only reproduced the relevant portions of the orders passed by this Honorable Lord where their assurances has been given.
Yes.
Their first assurance was given on 15.
My Lordship, may kindly say on
Anyway,
15.
Anyway, Nitoy is only a proxy counsel. That you must be having, they must be having copy of all our orders.
Yes.
Lordship, I have only
I have only reflected the orders.
Last, the latest order, Lordship, passed on 8.
Get copies of the orders, the
Lordship.
daily orders passed, where we have recorded your promises, our discussions.
Yes, Your Lordship.
and what we have been following.
Go through this,
Lordships.
And then come
and
if,
and if good sense prevails,
Lordship.
we'll allow you to file the additional affidavit.
Yes, Your Lordship.
But if good sense prevails, come back.
Lordships.
think through it. Think through it. Think through all the developments.
Lordships.
Whatever.
Let us not forget, because this is the proceeding of the court.
Yes, Your Lordships.
And
We
these
go
are
by-
affidavits.
And affidavit-
Supported by submissions supported by affidavits.
Yes, Your Lordship. I'll apprise the,
These are statements sworn on affidavit.
yes, Your Lordship. I'll apprise the counsel for the clients, Lordship, the applicant, Lordship.
Whatever it is, it's up to you. We've made our mind clear today. We've not made it very obvious,
Yes, Your Lordship.
but we've just given you a hint.
Lordship, if the order of the compilation of the order can be furnished
No,
to
I'll
me.
furnish a copy.
You have sent the
Furnish a
copies.
copy.
Because the orders is with them. It's only a list of dates. They are having all the orders.
You take the orders, copy of the orders.
Lordships.
You have a whole winter vacation.
When can you
Yes,
come
Your
back?
Lordship. Lordship,
My lord, my respectful submission is, if the council for senior council or other councils for respondent number 12, they have difficulties today, why not give an opportunity to them tomorrow?
I don't know whether,
Lordships, it will not be possible, Lordship, as informed, because the main
Because-
council is indisposed.
But because
Lordship-
lordship, in that case, because today it was fixed with their consent. So, my lord, if it has to be adjourned and fixed, it should be, a cost should be imposed.
Let us not someone
My
take
lord-
us for a joyride, man.
my lord,
We are all,
we are-
we are all having an
Adjournment with cost.
Lordships,
Because, my lord, this is not the way to deal
Mr.
with the
Mr.
subject matter.
Amicus Curie, the adjournment with cost, we don't intend to do it because we have other things in mind.
Lordship, I'm only expressing the
We have other things in mind,
lordship.
but in the, Nito is handicapped.
Yes,
And she's
my
aware.
lord, that part aspect,
So
I appreciate.
appropriate orders, since we know that no settlement could come in
Yes.
terms of order passed earlier.
Yes,
NHDCL has issued the termination.
Termination orders.
Now appropriate orders will be passed.
lordship, yes. Fine, lordship.
Because it's very difficult to deal with an individual or a firm who doesn't have that integrity and has taken everyone as for right. Because there is a saying, my lord, once bitten, twice shy. So
That's-
it's very difficult for us. We are divorced in a sense.
Should have filed by
One,
yesterday.
one more issue, Mr. Borgohan.
My lord,
Now that the contract is terminated
my lord.
with the respondent 12, now how do you intend to go about?
In fact, your
So
lordship,
far, package 3 is concerned.
in fact, lordship, on 11, on the last order, 8/12/2022, the NHITSLs were directed to file an affidavit on that point.
Correct.
I don't know whether the affidavit is,
Your lordship,
I'm here to receive a copy,
Your
whether it
lordship-
is filed or not.
Yes, yes. We
Your
have
lordship,
directed
we have filed the affidavit on two aspects. If the last order was concerned, there were two aspects, was that whether after we received the money from the Oasis, did we comply with the direction given? We have done it, my lord. I have got the copy of the FDs. Now,
Have you submitted?
we have filed it, my lord. It is in the registry. I don't know, it is, my instruction council has said already filed. It is in the registry. Huh? They filed.
Get the.
And second aspect, your lordship, as far as the alternative, my lord, as far as the alternative is concerned, looking into the various factors, we are making it that the larger interest of the public is concerned. We are at least making the two lane in a full phase. Because of Oasis actions, the entire situation has come to this point, my lord. So what happened is that the project was about 138 crores. They bid it for 111 crores. We gave them till 30 crores. They have received 30 crores, 87 lakhs they have received. We have paid to Oasis. So since they moved out on the last couple of months back, so the road condition got depleted, my lord. So what we did is that we went for maintenance work. We gave work to the two individuals, two firms. One was T. Tachu and Co. So he was working, but we didn't find him to be very satisfactory, to be very honest. So we terminated him. We brought in another party. Now, your lordship, everyone who is traveling, they can find that the work is going in a full stream.
Which party is
The Chavu and Co. I will be requesting this honorable court to implead him as a party in this matter. Chavu and Co. So, but the money which is required, this money is being all been taken off from the Oasis amount, my lord, 111. Because we don't have money extra. It is from that amount only. So, my lord, that is one aspect. The maintenance work is going on. But as far as package 3 in a whole, my lord, I'm afraid we have to go by the book. And in the process is that we have to call for, again, the process has to start from scratch. That is, a DPR has to be prepared, analysis has to be done, approval has to be done, same process from beginning A. So what will happen is that by the time we call an NIT, the working season goes away. That I have praised before this honorable court on 28th when your lordship passed that order liquidifying Oasis account. On that day also I made this submission, my lord, in the presence of the officials. Today also I'm making the submissions. So at best we can do is that we can maintain the two lanes, my lord.
Oh, go ahead. Is it a hint given to this court that this court should intervene into this matter also? Is it a hint?
Lordship, I am in support of that. The other day I was making a submission that time has come for this honorable court to think out of the box
Yes.
and take a decision because twice we have failed. And my lord, working season will be over. And if we go by the book, then we'll have to wait for 2024 again. So, my lord, it's a fit case in the interest of public service. Sorry for intervention, but then it's a fit case where this honorable court should intervene and give certain direction to NHIDC to think out of the box and to implement the project, my lord, in the interest of public.
My lord, as your lordship has pointed out, and what my learned senior amicus is making it, being from the NHIDCL, my lord, your lordship, which will be for me, the command, we will definitely look into it.
That's what do you say?
If the amicus can propose something, if your lordship even propose, we will look into it. Sir. Yes. When is the vacation day?
If we permit you to go according to the book,
My lord,
first thing is the time factor. 1 year is gone,
my lord,
2024 it will come.
my lord.
Plus, you'll bring some other contractor who may do the same thing again and go back, doing nothing.
My lord.
This is the second contractor.
My lord. Yes, your lordship.
Now it will be the third contractor who will be running away. I'm
My-
telling you. I'm telling you.
Lordship.
So now we have to intervene.
Your lordship, whatever direction your lordship desires to pass or intend, subject to my limitations, my lord, we will definitely look into it. That assurance I can give from NHIDC.
Do you have any authorities from the NHIDC?
My lord, I have called him the GM.
Have you come across such a situation in the past? Such a situation in the past?
Anywhere.
Anywhere in India?
No, sir, not to my knowledge.
So then give us your idea, how do we resolve this so that the road is completed within this working season? The people don't suffer any longer.
Sir, we intend to give 2 lanes, sir. That will be given for the package 3 completely. Since we have a maintenance contractor, we have the contract also, we have the provisions also. Going for 4 lane requires much more deliberation, sir, because it is one time thing that has to be constructed. It has to sustain, sir. There are issues. It will be difficult to give a 4 lane within the next 3 months without getting a proper EPC contractor, sir. It is slightly technical. We have to go by the book, sir. That is as per proper contract procedure.
No, in normal circumstances, that is, what you say is right. We are calling to a situation where the project has been stuck for the last 4 years, and that too on a national highway. So time has come for us to think out of the box. And you being the authority, a man with experience, if you can throw some light as to how.
So your lordship would.
What are the alternatives? What way?
Sir, it would be outside my purview to come to this because it is being discussed at the highest level. Delhi office is also discussing on such issues, sir. But this is the thing which we have been working on to go by a proper procedure because there's no other thing available to us. There's no other recourse available to us, sir, in the parameters which we are working, sir.
See, as local judges, we should consider this, that it's fortunate these cases are coming before local judges. We know the terrain of this area. Up to package 3 and 2, package 1 and 2, terrain is fine. There's no issue involved. But so far as package 3 is concerned, the terrain also we have to consider. The soil and all this, and maximum landslides takes place in this package 3 area. Now, it's such a situation that an outsider or a contractor from outside Nagaland would not be in a position to cope with such terrains.
Man who has no experience.
Who has no experience. They will come, see, I don't know, engineers are there. Obviously, engineers are going to verify.
Lordship, may I, please? Lordship, one suggestion is that, of course, to think out of the box and to shortcut the matter in the process, in the selection process, my lord, your lordship is sees of the matter. Now, one aspect of the matter is, lordship,
contractor for package 1 and 2. 99%, 98% job done. All the machineries are on the ground. Because tomorrow, if any contractor, local or non-local comes, they have to require little time to come and assemble the machineries and all that. So all the machineries are on the ground. So that is also one way of exploring things. For the initiatives to negotiate with the contractors of package 1 and 2, so that the machineries will simply shift, and they have experience now. Last 4 years of experience is there on the situation. So that is one way of looking at the matter.
That's what.
Then secondly, Lordship, as the GM has really pointed out, if the scope of the work for two-lane maintenance is enlarged, so that the ongoing contractor can finish the two-lane properly by the local contractors. That is also another aspect of the matter that has been looked into. And finally, in all those landslide areas, you may like to come with some. I remember the general manager was the other day. He was expressing about the need for some tunnel one night, just here in the deliberation. So, my lord, if in some areas where specialized jobs are required, what is the harm if the contract is split and accordingly, different people are assigned different responsibilities? That is also one aspect of the matter to think out of the box. So, my lord, two aspects of the matter, my lord. Either this honorable court give a direction to NHIDSL to come out with a plan of action and file an affidavit. So then, my lord, if it is convenient during the holiday, I think we are going to have a vacation bench in Kohima, if 18, 19. So we can fix a date in a short time. They can come with certain proposal, and this honorable court, if it is on public interest, can give certain direction so that Lordship, the working season will not be lost. I know your limitations. I know your limitations. Yes. 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 So you. Yes. Yes. I understand. I understand difficulties. I understand you. People only, unfortunately, the contractors and they don't work. That's the unfortunate part. You have done your job.
Manager, sir. You see, you're talking about all those technicalities and all that. I think you can work a little harder and then complete all those formalities so that the work starts before the working season ends, so that at least major portion out of 100, at least 30 or 50% of the work can be done during this working season. Another working season is not lost.
My lord, as far as your lordship's query to the technical aspect, what I have been told and what I have been apprised, two-laning work, all-weather two-laning work will be there. But the lordship's, as far as the matter pertains
Just a minute. When you talk about the two laning, now you are maintaining, right?
My lord,
So why not complete that two lane? Is there any impediment on that? Yes.
we were doing it, sir. We were doing
No,
it, sir.
no, complete in complete form. All the two laning
We will do
in
it.
full form.
We will do it. We will do it. We will do it. But
Now, why we are talking about technicalities? We know that all those discussions and all you will need to go through. So, and it is not a new project. You already have all the backup documents already. You hasten it in the interest of the public. Finish it in December. Finish everything in December, everything.
Your
And then-
lordship, if your lordship, what my senior colleague, Amicus says.
No, but just a minute, so that working season is not lost.
Exactly, that's the reason why, lordship. If your lordship wants me to take on the entire project package 3, if I go by the books, your lordship, it will take time. So tomorrow, after in the month of, for example, in the month of February, if this matter is there, I will be again put in the docs, NHIDC. I don't want that because G20 is coming, my lord. It's a matter of national pride. G20 will be coming. In the month of March, we are going to hold it in Kisama. And I have been told, my lord, a lot of pressures are there. Work.
That's why we are saying, that's what we are saying, we are aware of all these things. That is why, well, going into all those technicalities, though it will take some extra miles
So
for you,
my respectful
burning
submission
of your candle at night, you finish the work so that the working season, which is precious, these two, basically January,
That is
February,
why, my lord,
March, is not lost.
What I'm suggesting is that why not this honorable court direct the NHITCL to have a negotiation with contractor package 1 and 2.
That's what we're thinking.
Yeah.
So
The
that
lordship passes
because
on to
lordship,
Oh,
look into it, my lord.
because the issue is this.
But the package 1 and 2 contractors also not here. Council. is
No,
doing-
his counsel is.
His,
Are
my lord,
you,
the-
are you willing to have a
Contractors are also here, my lord.
thought on this issue?
My lord, may it please, my lord, as far as this package 3 is concerned, my lord, now package 1 and 2, because of this financial concentration,
That-
like you
that-
said, my lord,
one and two.
yes, my lord, but my lord, see, I'll try to convince my client, looking at the public interest, looking at the national priority, I'll look into that, definitely I'll look into that, my lord.
No,
my lord, the issue is this. For the ongoing
can you,
maintenance, for the ongoing.
Mr. Luika,
Yes, my lord.
your clients are not here? Are they here?
My lord, the general project manager is here, my lord.
Oh, then why don't you have a talk with him?
We can take up this case a little later.
A little later.
My lord,
So
Have a
we
talk.
don't waste time.
yes, my lord.
You take some instructions because now it's a do or die situation now.
And
My lord, my lord. My lord, I have been working here for the last
My lord,
more than 6 years.
The issue is this. Let us not, we have to be very clear, my lord. There is an ongoing contract for 2 lane. The local contractor is doing, so, and it is a instruction.
it is a maintenance work, my lord.
But it is maintenance, but what, according to the sense I'm getting from the general manager is they are going to upgrade the work so that 2 lane with all
Is
the markings will be completed, but in the ongoing work, which you will upgrade. So that way 2 lane is a short. Because of G20 now, they are going ahead, so that 2 lane is, that we will do. So for the remaining 2 lane, and in the landslide areas and other portions, whatever clearance and cutting of the lordship, earth cutting, all that, it is for that we are concerned.
All right.
So that has to be
All right.
made clear.
That Mr. Lukang has heard it. So have a discussion with your client. We'll take it up later on.
Come back after some time.
My lord, if package 1 and 2 can be heard, my lord, at this time, my lord, I.
No, we'll hear you all together.
We'll hear.
For motion, item number 3 and 4.
My lord, I have filed the IA praying for a delay condemnation of 346 days, my lord, in approaching this honorable court, my lord. My lord, the applicant and the appellant in the criminal appeal, my lord, he is a daily wage earner, my lord. And then even before the trial court, he was represented, my lord,
Who's responding to?
the FIR complainant, my lord, and the parent of the victim, my lord.
But Cindy Amal and the council for the appellants. Issue notice. MS Mary, Leonard, public prosecutor,
Yes,
appears for the respondent one. the appellant to take steps for the release of notice on the respondent to by registered proceeding within 1 week.
My lord.
After 4 weeks.
Obliged, my lord.
Where's modification?
For motion, item number 5 and 6.
My lord, here there are some peculiar circumstances, my lord.
6,000 days.
Yes, my lord. 6,031 days, my lord. And my lord, it was only through the good-spirited actions, my lord, of some paralegal volunteers of the Nagaland State Legal Services Authority, my lord, that the petitioner became aware of his right to approach this honorable court, my lord.
Okay.
Now, my lord, he was convicted for 376 and 302 of the under the Indian Penal Code, my lord. Now, my lord, what the learned trial court held is that, my lord, he had sexual intercourse, my lord, with
We are not going into merits now.
my lord.
Heard Sunday Land Council in the IA for the petition, for the appellant. Issue notice.
They have been sentenced for how many years?
Life.
Imprisonment for life, my lord.
Who is the complainant here?
My lord, that is the issue, my lord. Now, my lord, this is a legal services case, my lord. So the paralegal volunteers, my lord, and the penal lawyers stationed in Peck District, my lord, they tried to obtain the LCR, my lord. My lord, but it seems, my lord, the LCR could not be, is not available, my lord. It seems, my lord, there was a shifting of the court buildings, and then the LCRs could not be located. And even the impugned judgment, my lord, it was obtained from the district jail authorities at Peck, my lord. So, my lord,
Mr. K. Angami, Leonard, public prosecutor, appears for respondent. It is also directed. Do you have any, you want to file any objections? You want to file objections to the condemnation application?
Lordship, allow me to go through.
Okay. Appears on behalf of the respondent, sole respondent, and press for some time. To enable him to receive instructions. So, the appellant, it is further directed that the appellant shall make the complainant a party as and when the appellant comes to know about
my lord.
list after 4 weeks, 2
Well-
weeks.
4 weeks, Lordship.
4 weeks.
Obliged, my lord.
For motion, item number 7.
May please, Lordships.
Impleadment of the contractor, is it?
Yes, Lordship. This IA is for implement of contractor.
Anybody
order
for
dated
the
14
respondents?
Lordship.
Union. Who appears for the Union of India? It's okay.
Yes, only for the state.
Shameful.
Yes, yes.
Have you served copy on the Union?
Yes, Lordship.
Where? Where have you served copy?
Lordship, I've served it to Sir Moimchen, Learned Counsel.
There is
He is a
not a
government,
union.
government advocate.
Union, respondent number
For
1 and
union-
2.
May I please, Your Lordships, this morning I received information that dispute between the contractors are still continuing and SLP has been filed in the Supreme Court. So, Lordship, if you would kindly allow me to find out whether that is true or not. So may this matter be listed after vacation, Your Lordship?
Meantime, serve a copy on the Union of India.
Yes, Your Lordships.
Request made by me to call the legal counsel for the applicants, list after winter vacation. In the meantime, learned counsel for applicants shall furnish a copy of the present IA to the learned CGC within the course of the day.
For admission, item number 8 to 41.
Lordships, I filed my affidavit this morning, Lordship, with regard to the compliance of the last order. Whether the request has reached, Lordship.
Lordships, as directed by this court, we have also inspected, and this is our report, which is placed on record, Lordship.
No, you'll have to file it, no? Have you filed it?
Lordships, yes, informally we are giving, Lordship.
No, you filed it. It's probably, it's a PIL
In affidavit,
by
Lordship.
way of an affidavit.
Okay.
Mr. Mazui, what is the this thing? We asked you regarding the creation of posts of the staff, isn't it?
Yes, Lordship. Lordship,
What step has been taken?
Lordship, the proposal are already gone, Lordship. We have proposed for some certain posts, Lordship, as of now to man the administration, Lordship.
How much?
Lordship, may kindly come to Annexure 29, page 10.
No, how many posts?
Lordship, there are different categories, Lordship.
Page 10.
Page 10, Lordship, yes. Lordship, may kindly come to the column, Lordship. Designation post, Lordship, requirement as per NFC regulation. The column, Lordship. The fourth column, Lordship. Faculty, 24 posts to create. Then tutor, resident, and other doctors, 20. Nursing personnel, 133. Technical, medical, Lordship, 35. Technical, there's non-medical, 29 posts. Ministerial staff, 80. Then ancillary staff, 130, Lordship. Total of 434. And it's under the active consideration of the government, Lordship.
Now, at what stage?
Lordship, government is to finalize the post creation, Lordship, and then the post will be advertised accordingly.
No, when are you advertising? Because you are planning to start your college in July.
Lordship. Now, Lordship.
After the creation, you have to conduct
Yes,
recruitment.
Lordship.
Recruitment takes time.
Yes, Lordship, may kindly come to column 3. Number of posts adjusted under sanctioned posts available at NHK. We are going to use staff from the Naga Hospital Authority, Lordship, on the petition.
516.
Yes, 516.
But that alone will not be enough.
Not enough, Lordship, but to run, Lordship, to run. And Lordship, the Dean has already joined the service, Lordship, the post on Monday, and she's actively pursuing the college administration parties concern, Lordship. The 3 consultants have already been appointed, Lordship. They have started functioning from the administrative block. They've already started functioning.
So what have you precisely stated in the affidavit?
Lordship, may kindly come to my affidavit, Lordship, at page number 7, paragraph 3, Lordships. I'm allowed to read, Lordship. That answering department begs to state that as directed by this Honorable Court by order dated 30/11/22, whereby the medical department was directed to file affidavit as to the manpower for hospital administration. In this regard, by letter number so-and-so dated 7/12/2022, the department has sent a proposal for the various category of posts for NIMSR, that is Nagaland Institute of Medical Science and Researchers, in general and more particularly with the administrative staff, which is under active consideration of the government. The answering department would like to rely on the proposal as to the requirement of the NMC insofar as it relates to the hospital administration at the time of hearing. Mention may be made that the director cum dean had already joined her posting and had resumed her duties. Also, the 3 consultants, namely the technical consultant, hospital administrator, and procurement consultant, have already started functioning at the administrative block building whereby rooms have been allotted to them for their official purpose. So the ground floor, Lordship, of the administrative block have already been allotted to have already been taken over by the NIMSA, Lordship, and the 3 consultants are functioning from there, even the dean, Lordship.
No, but then we wanted, when are you going to create the post? When are you going to?
Lordship, the proposal
go
has
for the
already-
recruitment.
Yes, the proposal has already gone. Besides the deputation, Lordship, besides the deputation,
Proposal is gone. All right, that's good. But
Lordship.
then we should have a timeline, no? Because you have a July target, isn't it?
yes, Lordship.
And your medical council is coming.
Yes, Lordship.
Unless you have these staffs in place.
Lordship. That's why,
how can
Lordship.
Anybody allow it to run a medical
Yes,
college?
Lordship, the column 3, where I have stated Lordship, we are going to bring from NHK.
No, that we have understood.
Yes.
But that will not do because NSK, I don't think they have any excess staff there.
No, from their Lordship, we are making adjustment, Lordship, because whatever is required under NHK, and not only under NHK, Lordship, people will be brought from the medical personnel, the staffs will be brought from different districts, Lordship, where they have an access. Administrative staff is concerned, Lordship.
In our experience, in all these PIRs,
Lordship.
we have never heard of excess staffs in Nagaland. In fact, we took up this matter,
Lordships.
especially because of the shortage of staffs and
Medical
personnel.
personnel, Lordship.
Yes.
Like doctors.
So how are you going to bring these 500? How are you going to mobilize these 516 from the NSK? Doesn't sound very practical.
Lordship, that's how they have department have worked out, Lordship.
So
Then NHK will again collapse.
yes,
No, Lordship.
Obviously.
very obviously, it's obvious. 516 from an existing
Lordship,
institution is a huge number. If you say 50, 100, then yes, we may accept it. But
Because, Lordship,
16 staff to give her from another institution is
Lordship, during the COVID, more than 200 plus has been appointed.
No, Mr.
Besides the
Mr.
existing.
Mazui, why we ask you
Lordships.
to file an affidavit as to when are you going to create a post and when are you going to complete the
Lordship.
recruitment?
Lordship,
We want to see how serious you are.
Lordship, the post has already been
This-
earmarked, the
this-
requirement.
This doesn't look like a serious step.
Earmark is a different thing. We want to know when you're going to do it.
Lordship, the proposal is already with the government, and I've inquired.
That's why we asked the government to file affidavit.
Lordship.
Now, whom do we ask to file the affidavit besides the chief secretary? Whom do we ask, Mr. Mazun?
Lordship,
Mr. Imsong, you tell us. Besides the chief secretary, whom do you ask to file the affidavit?
Your Lordship, last time we have already filed
No, no,
as
no.
per the direction. And the remaining amount in due course of time,
We have asked you to file an affidavit, the chief secretary to file an affidavit. When are you going to create the post of administrative staffs? And when are you going to conduct the recruitment and complete the recruitment? Because the target for starting medical college is July. You can't run a medical college without a staff, isn't it? No, it's the time to be serious now. Not having a medical college in a state, when your neighboring states are having 4, 5, and in Assam now they're going to start another 7 or 8, as I saw in the newspaper.
Lordship, Lordship, you kindly see the last order, Lordship, passed on 30/11/22. At paragraph 3, I was directed to file an affidavit, Lordship. The order was on our query in respect of manpower for hospital administration. Mr. So-and-so Learned Council submitted that 3 consultants so-and-so have been appointed, and they have already worked out the requirement, and the same has been submitted to the government for creation of post. You submit that, he will submit a copy of the proposal on the next date. So this is the proposal that we
The
have.
proposal.
Yes,
But that's why we are looking at the proposal.
Yes, Lordship.
So why should linger on this proposal under consideration, proposal under
Lordship, the procedure, Lordship,
will be a non-starter. Will be a non-starter. When we are talking about a medical college, as important as a medical college, that is the
Lordships,
first medical
Lordships.
college. we expect a little more seriousness than this.
Lordships. Because Lordship, we have to go phase-wise, Lordship. Now,
See, the central government has said yesterday, if I am correct in the newspaper,
Lordships.
so many medical colleges are being opened in the northeast. They have given the list of completed hospitals.
Lordships.
Nagaland, only one, the first one.
Yes, Lordship.
We are not able to open it. So isn't it time for everybody concerned to take this matter forward on one footing? Under consideration. Under whose consideration? Under your consideration. So you should be able to tell us when are you going to clear this and when are you going to, actuate it with appointment.
Lordship, as far as the department is concerned, as per the requirement under the NMC regulation, Lordship, LOP, we have placed our requirement to the government, Lordship.
Right.
Now, the information that I have received, Lordship, is under the active consideration of government, Lordship, which will be done very soon, Lordship. That's the instruction I've received, Lordship. And basing on the instruction,
Mr.
Lordship,
Song, you have any instruction? When are you going to clear this 434 creation of posts?
I have to take time for instruction.
Lordships, I want to press whether if this honorable court can kindly give a timeline, because Lordship, this issue of appointment has been dragging on for the last many hearings, Lordship. So,
Chief Secretary, because unless the approval comes from the side, I cannot appoint. Yes.
All right. Mr. Song, seek instruction. Of course, Mr. Mazvi represents the department only. So you're here to represent the government, Chief Secretary.
Lordship, also the
MS Nitoy, learned counsel appearing for the petitioner.
Lordships, perhaps on the next date, if the state government, learned AAG comes with a clear instruction as to when the appointment will be made, Lordships.
That has sought for time to file a report of the team's visit to the medical college campus as directed by us in the form of affidavit. The Mr. Mazvi. Mr. Mazvi, this affidavit is filed by whom?
the Secretary, Lordship.
Secretary Medical.
Yes, Lordship.
Medical and Health and Family Welfare has filed an affidavit as directed by us, showing that 434 number of posts of administrative staff, also administrative staff, has been proposed by the department and it is under the active consideration of the government.
Lordships. Let the Chief Secretary.
Mr. Imsom, Lieutenant Additional AG, submitted. He may be given time to seek instruction as to when these proposals will be cleared and recruitment conducted and appointment completed. First off. In view of the submissions of the land councils, time is granted. List the matter at hand. Right after winter vacation.
Lordships. Lordship, I've also filed the status report.
You
With regard to yes, the photograph has been annexed.
Just about that. We have also taken note of the status report filed by the Medical department.
Lordships. Oblige, Your Lordship. Yes, from item number 8 to
Yeah.
For admission, item number 43.
May I pray that part of matter can be taken up? We have
Okay.
Call up the first item.
1 and 2.
We hope you had a fruitful discussion.
Yes.
Yes, please, my lord. My lord, I have already briefed my client, even at the top level. We are contemplating on it. And then, my lord, what happened is, since this cannot be done in a hasty manner also, this is the lifeline of not only one state, but of various
Exactly.
states. My lord,
Exactly.
the road has to be sound.
Yes.
It cannot be done in just the way we want it. It has to be technically sound also, my lord. So, my lord, what happened is, my suggestion and my proposal is, let the NHATCL prepare DPR, submit it, I'll analyze it, then we'll go for it, my lord. I'm all for it. Now, even one project, even in Assam, it's already completed. I have the manpower, I have the mobilization, I have the machineries. Even for package 1 and 2, I'll all pour it in and I'll give my best, my lord. At the earliest time possible.
My lord, what my learned friend is suggesting, since your lordship has already hinted his mind, this honorable court. So what I can suggest is that, since time is the essence also, I understand. So if their authorities are there, means their technical persons are there, why they don't have a deliberation with us tomorrow? I can make the arrangements. Let us there were deliberations. And what are there? Because there is already a DPR is there, already the schedule is being there. So they are all well versed in this area, topography also. So what is there? What they want to make some amendments. So let them say to us so that we can take a call, because we cannot take a call in Kohima itself, my lord. It has to be processed, due process is there, so that it can cut, the time can be cut. So let them have a deliberation with us tomorrow, and we can get back to this court on 16th, day after tomorrow. That will be, it will be more fruitful one, your lordship.
My lord, unless the DPR is prepared, I have to go into it, look into it, assess it, and then I'll come it. Because to be very honest, with this
DPR is
honorable court-
already there, isn't it?
My lord, DPR, without DPR, no project can be done.
That's why it's
So there is
already-
there is a DPR.
So if you want some modifications,
Changes.
Yes,
changes.
my lord, it cannot be done at the earlier DPR. Because, my lord, now even...
That is why
Yes,
we're
yes, my lord.
saying, that is why we're saying, why not you have a
Study of the,
sitting with the NHIDCL, trash out the matter, see that whatever is required to be modified can be modified, and all these issues. Come back to us the day after tomorrow.
I'm going to comment, my lord.
My respectful submission. My lord, a day may not be sufficient.
Maybe.
Let
But
us be honest.
the issue is,
Let us be realistic with the issue.
day
So for
after
them
tomorrow is the
also,
last working day.
so for them also, my lord, he may require little time. Definitely, one day may not be sufficient. So, my lord, my respectful submission is whether we can have a sitting during the vacation, if there is a vacation bench. If not, my lord, one day to be.
Vacation bench.
Or lordship, we can have. No, sir. What I'm proposing is that
January. When is the vacation bench? Ninth. Arnav, confirmation has come.
Lordship, all of us are in holiday mode. I have also planned to go out, but then. But if it is on vacation, then let it be on 19, not later than that. But if it is on vacation, let it be on 19 itself, not later than that, my lord.
19th of?
December. If it is vacation, then if it is taken up on vacation bench, let it be on the very first day of the vacation, that is on 19th. Otherwise, not later than that.
January,
No. Your vacation means Lordship is coming off from 19 December, na? This,
9th of January,
huh?
9th of January.
My lord, my Bihu festivals are also there, my lord. I hope you understand, your lordship.
No, that I
But then for one day, everyone will sacrifice. Because we have to arrange a lot of things. For a day you can come. It's possible. January. Sir, let us have an in-principle discussion tomorrow. That is what I'm saying. You will give you sufficient time.
See, last working day is 16th
Yes.
of Friday.
My lord.
Brother is willing to sacrifice one day in public interest. So we can have it on 19th, subject to confirmation from the principal seat.
Lordship. My lord.
Can you complete your exercise?
In
See,
this,
as we said, it is a peculiar circumstance
Yes.
in the interest of the public.
Well, we really appreciate lordship. Because one of January, my lord, 19 is fine, my lord. 19 is fine. If lordship is willing to take.
The 19th of January.
December. January?
call the call the register. Okay, join register.
Join registrar.
My lord, in the meantime, we can continue with package 1 and 2 till that issue is settled. My lord, there is one instruction I have received. Your lordship will be aware, if I can recollect, on 28/9/2022, when your lordship passed the order, because we anticipated that what the earlier contractor has done, Gayatri, without indemnifying us, they went back. And my lord, though contempt proceeding was to be initiated, but court did not proceed because they have already terminated. So we anticipated it. So we apprised this court, and court has blocked the amount, that 11 crore. Now, in this IA which they have filed, they are asking for the modification of that order, number one, and to release of the money indirectly, which they are claiming. My lord, second issue is that they have issued a notice from the Delhi High Court for praying for an arbitrator to be appointed, sole arbitrator, where the lease is same. So we anticipated it, and your lordship has assured us that we will take care of this thing. So now, my lord, we are this, because it's a public money is there. If today your lordship releases that money of 11 crore, because already it's a limited budget, my lord. So my lord may look into that fact, and because at least I have to be protected in the arbitration matter also, because they have done a lot of things, my lord. My lord, package 1 and 2, your lordship.
Yes, call up the IA 1 and 2.
My lord, for package number 1 and 2, my lord.
Some issues are common with package 3.
If you're playing that on.
Come by phone.
Assam, sir, right from 24, na, sir. 24. I know that. Poor rough holiday mode, sir. I know that. I know that.
Online does he want? Okay. But this 19 on confirmation to do. Okay.
My lord, may I make a submission of package 1 and 2, my lord? Yes, my lord. My lord, as far as package 1 and 2 is concerned, today I'm standing here before my lord, and I'm tendering my unconditional apology, my lord. I've not been able to complete, despite my intention, despite my commitment. My lord, here I have difficulties. The difficulty of which I was not able to complete this because solely on the financial concentration, acute cash flow problems in the construction site, my lord. My lord, since June 2022 of this year, the fund was not being released, my lord. I have tried my best. I have exhausted all my resources. I tried to mobilize whatever I can. Around 50 crores I have done. I have mobilized. Today, I'm not in a position. I should be very sincere to my lord. I have no other source. And I'll solely rely on this honorable court to kindly review the order of 28th of September 2022, directing the NHIDCL to release only the pending bills, the running bills. Today,
When are we finishing 1 and 2?
my lord, as and when the bill is released, I'll complete it in 3 weeks' time, my lord. In full respect, my lord.
Are you sure?
My lord, as an officer of the court, all
You
that
may be saying that, but can your clients do it?
Yes, my lord. The sole problem today is only the cash flow, my lord. Since June, my lord, my fund has not been released, my lord. I tried my best. Wherever I can, but my lord, the other side will agree with me. If today now, the locals, they have already destroyed most of my machineries now. Around 50 lakhs worth has been
My lord,
demobilized,
my lord,
have been
issue-
destroyed, my lord.
Lordship,
I
kindly
have
allow me to-
market liabilities, my lord.
Lordship, kindly
The
allow me
local
to-
liabilities, my lord.
Lordship, kindly allow me to intervene here, my lord. I have also make my independent inquiries on the issue because, my lord, ultimately the focus is to finish the work. So, my lord, I have, without any prejudice to anyone, I have made my independent inquiry. It's a fact that they have not energized, they have not received their running bills since June. Last payment was in June, so last 6 months, they have not been released. That is, it's a fact. Before, even prior to the order of this honorable court, they were chasing for their running bill, but for this reason or that reason, the fund could not be released. It's a fact. And Lordship, it is also confirmed that there are, after the direction of this honorable court, they have their bank credit is also exhausted. That is confirmed, and they have also procured a loan from the market with huge interest to the project. That is also I have verified. But in spite of that, little work is yet to be done. About I think as per the engineering, I have confirmed from the authority engineer. Now about 1% work is left. Other issues. So, my lord, looking at the larger picture, my lord, if their pending bills, if that can be released in the larger interest, then this headache of every time raising issues about 1 and 2 will be completed, and with the assurance, my lord, with an assurance from the contractor to present here that beyond 3 weeks, at any cost, they should not be praying for extension of time if some fund is the running bill is released for them.
We are granting you 4 weeks.
Your Lordship, may
My lord,
my
obliged, my
submission
lord.
also.
I'm deeply obliged, my lord.
My lord, at least record my submission. As far as package 1 and 2 is concerned, my lord, they have an outstanding, like we owe them around 17 to 18 crores. Now, my lord, what I have been instructed by my clients that we have got no hesitation to release the amount. But if we follow the procedure, it will take another 10 days financial. We have to see all the inputs and all. So why in that case, my lord, since only 1% or 1.5% work is there, my humble submission is that per package 1 and package 2, let 6 crores be released. We will be releasing forthwith, so that balance adjustment we can do when we get the work completion certificate. So that will suffice them, my lord. 6 crores, my lord.
Is it okay? My lord, my humble submission is, it is extremely low.
Otherwise,
my
it
lord.
will be difficult
I'm
for
only
us, my lord.
I'm only asking for the running bills, which is running into, as far my affidavit, as for my IA, it's around 26 crores, my lord. I'm only asking for that. There are BGs, there are other withheld monies, there are penalties that have been imposed on me. I'll complete it in
My
all
lord, it will
respect.
take time in that
Yes,
case.
my lord. But let that
It
running
will
bill
take
be
time
released, my
to
lord. I'm not
verify
being-
those bills, my lord. We might have to carry a joint inspection and all those things. So what I'm suggesting in a goodwill, that let us 6 crore per package be released, so we can do our due diligence after that. And that's a very genuine one, my lord. 6 crores, we have got no issue. Blindly we'll be releasing it, forthwith.
How much is pending?
17, 16, 17 to 18 crores.
No, you're saying 17, 18, he's saying.
My lord,
26.
as for my affidavit,
My lord, as far
for
as
my
I have
IA,
received instruction,
it is
so-
it is around 26 crores, my lord.
So, my lord, let
My
us not go to the sum of the amount. Let us not go to the sum of the amount. In that case, we have to do verification, audit. In that case, it will take time, will take up. So, what I am suggesting is that let us release 6 crores per package. That will be sufficient, my lord, at this point. Let us be very practical in this, I suppose, because if we do the due diligence, we have got no issue. What they owe, what we owe to them, we are going to give them as per the contract. But to do that at this present juncture, looking at the urgency, it will take time. So tomorrow they may come and say that because of 2 weeks it taken, we could not complete within 2 weeks. So that to avoid that circumstance, my lord, let me release 6 crores.
My lord, my humble request is let it not 6, but at least make it 10 crore each, my lord.
That's fair
Yes,
enough.
my lord, it is reasonable, it is fair enough, my lord. Tomorrow I don't want to come and tell it because of these shortcomings,
Board
the
boy.
progress has been
10,
delayed.
10 crores.
Yes, my lord.
Okay, my lord.
10
Obliged,
crores. When can you release it? Give the date. 10 crores for package 1, 10 crores for package 2.
Sir,
Obliged, my lord.
my lord,
Deeply obliged, my
my lord, that is the why. The issue is that now my technical team, they are saying if we release that 10 crore, before we have to give a joint verification report and all those things. So it was time consuming. So what I have been yesterday when I had a discussion with the higher ups, so they had an issue that at least release 6 crores, which we are competent enough at this point. Because the moment 10 crores, it will come up and issues will raise. So let us be very practical, my lord.
My lord, will be coming to square one again, my lord. Today, the locals here, which I have engaged, they have been praying. They have now already damaged some of my machineries, my lord. Now, I have not been even able to own my phone, my lord, because of all this. At least, I have been giving them assurance since June. Now, this is December, my lord. We as a Christian community in this state, I am also obliged to give them, my lord. They have been helping me this far. And this honorable court has never shut its eye since the day this matter is taken up. This honorable court has done much more than any other court will do. I really bow down to my lord, but at least 10 crore, my lord. 10 crore each. It is at the interest of the project.
10 crore, they're saying that they'll have to have a joint verification report.
No, my lord.
That will
It
take-
is
that
my
will
money.
take
It is.
some time.
It is my money. It is the work done payment withheld by them, my lord.
My lord, what they are saying, what I have been received, instruction is that if they raise the bill, for example, 10 crores, if they raise the bill tomorrow, so by due process, it will take at least 4-5 days for joint verification and all. After that, we will release it. So means 1 week goes. So if a lordship is saying that within 4 weeks they are going to complete that process, but at least we have to have certain amount in our bucket also, my lord. Lordship, I hope your lordship understand that.
So we give you 4-5 days for the joint verification. After that, you release 10 crores.
Yes.
After the joint verification, within which date can you give us, release the amount? That date you give us.
Sir, my lord, let me intervene, my lord, here.
My
Let
lord.
6 crore each be released instantly, and then 4 crores, let them do the verification, whatever they want, my lord.
Your lordship will appreciate
I'm not
this.
aggrieved to that, my lord.
My lord, that will be difficult. Your lordship, that will be difficult. There are some financial rules also because we are a PSU. What the moment, for example, your lordship, tomorrow they raise a bill of 10 crores. We have to pay them. But if we pay them before paying 10 crores, we have to do a joint verification. What they are claiming is 10 crores. According to my calculation, it is only 7 crores. So there might be disputes will be arise, lordship. So if you didn't follow in that process, what I'm requesting is lordship is that let the lordship make an observation that let them raise the bill. Let them raise the bill. We will do the joint verification, and accordingly we will pay. We will pay. We will make the payments. whatever is due, my lord, whatever own.
My lord, it is my money, my lord. I have
That's
done
why
the
your
work,
money
and
only
it is
I'm
my
going
money,
to
my lord.
give you.
Let 6 crores each package be released instantly, and then 4 crores.
That cannot be, it is against the
let them
FRSR,
take,
my lord.
Not
It is
even 1
against
week.
the
Let them
financial
take 4
rules.
5 days. Let them 10 days, my lord. I have not agreed to that.
One issue is you want 10 crores.
Yes, my lord.
You raise the bill, have a joint verification, they'll release it within a specified period of time. We're extending your completion of the work for 4 weeks.
My lord,
Because 1 week will be spent in the joint verification and all
my lord,
this.
the urgency is
Before Christmas,
even-
you will do it, my lord. Before
No,
Christmas, you will do it. My technical
Because-
person is there, GM is there. He's a senior officer. He told that before Christmas, you will do it.
My lord, the urgency is I'm not even able to station at the camp, my lord, now. The locals are threatening me, my lord. At this, I don't want to bring to my lord, but I have reached a position, my lord, that I have to bring to the knowledge of this honorable court, my lord. I'm in extreme difficulties, my lord. The local liabilities, my lord.
All right. You raise your bill, have a joint verification, release the bill by 21st.
My lord.
10 crores
My lord.
each.
My lord, the moment they raise the bills, my lord, of 10 crore or X amount, we have to do the joint verification. And the joint verification, whatever is agreed upon, that amount has to be released, my lord.
Okay.
My lord, if I cannot raise 10 crores each in that way
Okay, then we are saying on the agreed amount.
of joint verification, we will release the payments. my
Okay.
lord. On before 20 by 21st,
By 21st December.
my lord, 2022.
My lord, not later than that, because I have been giving assurance after assurance to my locals, my
Court
lord.
is passing an order.
My lord,
We
my
will do
lord.
it. We will do it. We will
And
do it.
when are you completing the work? Completion.
The day they release the money, 3 weeks time, my lord. I'll complete in
21st,
full
they're
respect, my
releasing
lord.
the money.
15th of January? 3 weeks. 3 weeks. Yes. By 15th of January, my lord.
Yes, yes, my lord.
3 weeks. More than 3 weeks.
Okay.
Yes, my lord. I'm deeply obliged.
And further compliance happen thereafter.
Yes, you do.
Yes.
My lord, as far as the IA is concerned, your lord,
is disposed. IA 178. Will
Obliged,
pass
my lord.
orders appropriately. You have raised your bill, have the joint verification. On the agreed amount, after the joint verification, they will release the amount by 21st, latest by 21st of December. You will complete your work by 15th and submit your completion.
Obliged, my lord.
my lord, for package 3, my lord, the new maintenance contractor has to be implemented as a respondent. We will, Shabu and Co, my lord, will give the name.
What is the,
We'll give
write it down and give it.
We have filed the affidavit in.
Then secondly, Lordship, subject to repetition, I'm making, the Lordship for the package, for the 2-lane, the ongoing maintenance work should be upgraded.
Yes, yes.
Because without a specific direction from this honorable court, the NHITSL will have difficulties because so far the sanction is only for maintenance. So without the direction from this honorable court, you'll have difficulties. So Lordship, may kindly keep that into consideration. That's it.
Upgradation of the
Yes, 2-lane.
two lane, and then you have a deliberation with the.
My lord, let it be reflected in the order sheet, my lord, because without the order sheet, I cannot give an opinion, my lord. Let it be reflected in the order sheet.
Okay.
And my lord, the IA which they have filed for the review, asking for the amount.
That they want to file an additional affidavit.
Yes, Your Lordship.
We are permitting them to file the additional.
Oblige, your lordships.
We are listing it on 19, subject to confirmation from the principal seat.
For admission, item number 43.
Last time your lordship has directed me to verify about the review. One of the my learned friend Nito.
No,
Lordship, I got the information from the Standing Council, State Standing Council, Supreme Court. She's informed me that she had not knowledge that about the filing of the review before the Supreme Court, Lordship. Review of the Nishivi's case, Your Lordship.
My lord, my submission is that Nishibi is a case of somebody, it's the wife who filed a deed petition. But in my case, it is a question of retirement. So these two are different issue.
Question of retirement means? You have not retired.
I'm retired.
Oh. No, that's what, post-retirement, no? You have come after
Right,
retirement.
right, yes,
That is why
yes.
we want to see what the Supreme Court says. Yes,
Nido. Kindly assess us.
Otherwise, the person in Atoli was the one who took up the matter, so she didn't receive any notice on that, Your Lordship.
Have you filed a review?
Lordships, yes, the case was referred to one of my colleague, Lordship. Lordship, I believe by now they must have filed because
No,
this was referred
This
since
morning,
last month,
I got
Lordship.
the information.
So, my friend is, I tried to contact her last time also, but she's unreachable, Lordships. So, if you would at least
Every time it's
give me some time,
unreachable.
Lordship. So,
Then we
to-
will have it on the opening day of the
No, Your
petition.
Lordship, even
Yes,
if
Your Lordship, that
Nishibi
will
is
be
not
better, Lordship.
covered also, Your Lordship,
No,
petitioner
let us
does
see,
not have.
let us see.
no, there's no much in a hurry.
Let us see.
Lordship.
We'll have
Much
it on the
urgency
opening
involved
day.
here.
Okay, list this matter again on 18th. Meantime, Nitya, if you can just assist,
Lordships.
not directly the board, you can assist Mr. Imti or Sukre
Lordship, I shall do
by
that.
giving them if anything has.
Okay, much obliged.
Much obliged.
For admission, item number 44.
Yes,
There is,
Likase.
yes.
Any
My lord.
objections?
No, my lord, with regard to, I have no.
Third MS, the software additional advocate general applying for the applicants. Stop by this application. The applicants are praying for condemnation of 132 days delay in filing the present appeal. Stop. We have perused the cause shown in the present eye, particularly para 4. Stop. Para. Mr. L. Castle and a counsel appearing for the opposite party. Sole opposite
Yes,
party
yes, sir.
has no objections in continuation of the delays prayed for. Stop. According to comma, the delay of 136,
32, my lord.
32
days in filing the connected writ appeal is condoned. IS disposed. Raise the writ appeal.
Your Lordship, I have a prayer for stay of the impugned judgment and order,
Tomorrow we will
Lordship.
consider it later.
Okay, Lordship. Then, Lordship, similar order may be passed in 45
All
and
this item
yes.
45, 46.
and 46. Yes.
All the IA disposed. But
Yes.
check, different dates under 132.
No, 132 common order, common judgment and
Okay,
order,
so we have
Lordship.
not-
Yes.
Same order disposed.
Much obliged.
My lord,
Just
blue-
say, list the appeal in its usual course.
Lordship,
My
here
lord.
I filed 4 analogous writ appeal. But the other one, last time the opposite party mentioned, so only these 3 are listed today. So it may be the present writ appeal may be listed along with the
There
other.
also IA is there?
Yes, IA, because
Without-
there are 4.
Without condoning that IA, how?
No,
can
no,
it
to
be?
list along with that case, Your Lordship, on the same day.
No, we are saying to list the writ appeal in its usual course.
Okay, Lordship, Lordship.
So if you want to file, you let it.
Let it come. Let the
Lordship,
IA be
Lordship,
taken up.
Lordship. Yes,
Tomorrow, day after, you can make a mention memo also.
Lordship. Much obliged.
Our pleasure.
For admission, item number 48.
May it please your Lordship. Lordship, I was directed on last occasion to file a compliance report as to the notification, application of the statemental rules.
So have you completed the rule?
We have framed the rules. Application, I sought for instruction, it has not come to me. So, Lordship, this matter may come up in the after vacation.
On request, I heard Mr.
KRK.
Kiarkal and the counsel for petitioner. On request made by Mr. Moinch, the senior government advocate, list immediately after the winter vacation.
Operation.
For hearing, item number 49.
Yes.
Lordship, it's an appeal filed against the bail cancellation under section 21, subclause 1 of the NIA Act. And
Charge sheet is submitted or not?
yes, my lord. Charge sheet is
Charge sheet
submitted.
is submitted.
And
How many witnesses?
8 witnesses has been concluded.
How many
Lordship.
total witnesses?
My lord, witnesses are cited more than 100, but
Oh.
we are not going to produce every witnesses. Only the relevant witnesses will be produced before the court.
No, the accused has been cooperating. Is he appearing in the court?
Yes, my lord.
So what is the need of cancelling the bail if he's appearing in the court?
My lord,
If he's cooperating?
my lord, just I would like to state
No. The most important thing is that the accused is present. Right? You have examined 8 witnesses so far, and he's appearing. So what's the need of him in the jail? You have already finished your investigation, that's why trial is going on.
My lord, all the 5 accused have got the bail, and out of 5, 3 declared as absconder and jumped their bail. And
All right, but he has not jumped. He has been appearing, regularly appearing.
though my lord is appearing, but the gravity of the offense is also, if I'm not going against the opinion of the honorable court, but the gravity of the offense is also considered is a major consideration, my lord.
How many days he was in custody?
5 years, 3 months, your lordship.
5 years.
And as of
Who is
date,
going to repay for him for 5 years? And supposing we keep him today, and at last he is acquitted.
My lord, before the 2 year has been expanded in due to COVID, and before this, the
Whatever
NIA
it is, COVID or no COVID, he was under custody.
yes.
Then
5 years.
5 years.
5 years, 3 months, your lordship.
What is the offense?
The offense is killing. The matter relates with the firing incident here held in Kohima in 2013, and in which 4 persons got injured, and one of them was died. And the respondent was the person who fired over that. This is the gravity of the offense, my lord.
That is the allegation, your
And
lordship.
this is the allegation, and some AK-47 and like arms has been recovered from the possession of that respondent.
I don't think there's any hurriness in hearing this matter.
So, my lord, we are being National Investigation Agency.
The trial is going on, no?
Yes, your
The trial
lordship.
is not disturbed.
Yes.
No,
You are appearing?
I'm appearing for the respondent, Nasaga Kini,
No,
your
no,
lordship.
is the accused
He's appearing in the court.
Every date, not a single date he has missed. Not a single
how
date.
many witnesses are there?
Only 8 witnesses. There are
No, no, no.
altogether 72 witnesses. 72 witnesses as per the appeal memo
My lord.
they have filed.
My lord, we are producing the witnesses every day. He cannot deny. But due to some problems, sometimes courts are not available. That's why the matter is being adjourned. But from the last 4 or 5 months, we are producing every day 2 or 3 witnesses per day.
You continue.
And it's not the delay on our part.
Lordship, CC was fixed in the year 2016. That also it was not done. Thereafter,
What was fixed?
CC for consideration of charges, especially with regard to my client, your lordship, who was arrested on, they have shown him arrested on 24.
24?
24/5/2016. But this is not the fact, your lordship.
All right, that.
23rd, he was arrested by the NIA. 22nd, he was picked up by the army personnel, not from his residence, from the residence of somebody else, while he was having dinner there. The owner of the house, he was an underground outfit. And NIA also admitting that the accused from whose house he was arrested, let me complete. Nothing was seized from him. It was the one who has absconded. They have mentioned the name was of one Kekato's house while he was having super, your lordship. So he was arrested. That is one part, your lordship. Lordship, all these years, date of even to cross-examine the PW1 who was before my entering, was examined in chief and cross-examined by other counsel. That was also taken more than a year. It was after our coming only now it has come into the streamline that every date at least one witness is coming, lordship. 1 or 2 witnesses after my learned friend has appeared. Otherwise, only date after date. Lordship, with regard to the bail, your lordship. With regard to the bail, I was in jail for more than 5 years, 3 months. With effect from 23/5/2016, lordship. My bail application was granted by the court below, lordship, on 10/8/2021. The authorities I have cited, the court below has appreciated the authorities. Considering the authorities, lordship, the bail was granted. With your permission, lordship, I will refer to the authorities. The latest decision given by the Honorable Apex Court also, I have the authorities of the full bench of the Guwahati High Court also. SCC 2021. In the year,
You are the appellant.
Yes, my lord.
Argue, Mr.
Lordship, as I have argued before the Honorable Court, that the matter relates with the killing or firing over the armed personals. And during the search,
The issue is, give us the grounds for cancellation of bail.
My lord, the ground is itself has been narrated in section 43D5, subclause 5 and 6, which says that if there is a prima facie case, then bail cannot be granted due to the grievous nature of the NIA related cases, my lord. And here I would like to cite the impugned order, my lord. Especially on 34, page number 34, my lord. Page number 34 is the FIR, which states that, the offense. And on page number 31 of the impugned order, it is page number 31 and paragraph 14. This court has considered the submission made by the parties, the fact that the circumstances of the case peruse the charge sheet and the connected documents. Upon examining the material against the present accused before this court, there is no doubt that there is a prima facie case against the present accused. The case is prima facie, my lord. The arms like AK-47 and ammunitions has been recovered from the possession of the respondent. Your Lordship, I would like to draw the attention of the Honorable Court over Section 43D sub clause 5 of Unlawful Activities Prevention Act. It says, Lordship, that notwithstanding anything content.
1 minute. Section?
Section 43D, subclass 5 and 6. My lord, it says that notwithstanding anything contained in the code.
Just a minute, just a minute. Section 43D.
3D,
Page number
subclass 5
25.
and 6.
D.
D, subclass 5 and 6, my lord. May I?
All right.
Lord, it says that notwithstanding anything contained in the code, no person accused of an offense punishable under Chapter 4 and 6 of this Act shall in custody be released on bail on his own bond unless the public prosecutor has been given an opportunity of being heard on application for such release. Further, the proviso is important, my lord. Provided that such accused person shall not be released on bail on his own bond if the court, on perusal of the case diary or the report made under Section 173 of the code, is of opinion that there are a reasonable ground for the believing that the accusation against such person is prima facie true. Further, my lord, in subclass 6 says that the restriction on the granting of bail specified in subsection 5 is in addition to the restriction under the code or any other law for the time being in force on granting bail. If all the circumstances exist, my lord, then Section 43, even though Section 43 subclass 5 makes a bar in granting bail in such heinous offenses. Further, my lord, the case is prima facie. The Honorable Learned Lower Court is also of the same opinion. My lord, in this case, the Honorable Learned Lower Court has relied very much on the finding of the judgment of Honorable Supreme Court, Union of India versus K. Najib. I would like to draw a center of the Honorable Court over there. My lord, in this judgment, the finding has been given in para 19. First of all, I would like to state in very short the fact of the case. My lord, this fact is related with the hand chopping of well-known T.J. Joseph in Kerala by the PFI persons. And the court has given the finding in para 19. Advertedly to the case at hand, we are conscious of the fact that the charges levied against the respondent are grave and serious threat to the social harmony. Had it been a case of threshold, we would have outrightly turned on the respondent's prayer. However, keeping in mind the length of the period spent by him in custody and the likelihood of the trial being completed anytime soon, the High Court appears to have been led with no other option except to grant the bail. an attempt has been made to strike out balance between the appellant's right to lead the evidence of its choice and establish the charges beyond any doubt, and simultaneously the respondent's right granted under Part 3rd of the Constitution have been well protected. This is the finding, my lord, and the bail was granted in the same like offense of hand chopping case in UAPA only due to the time spent in the judicial custody. Further, on what this ground this observation was based is given in para 15, my lord. The fact of the instant case are more egregious than those two above cited instances. Not only the respondent been in jail for much more than 5 years, but there are 276 witnesses left to be examined. Charges have been framed only on 27 November 2020. Still further, 2 opportunities were given to the appellant's NIA, who has shown no inclination to screen its endless list of witnesses. Further, upcoming lines are much important, Lordship. It also deserves mention that the 13 co-accused who have been convicted, none have been given a sentence of more than 8-year rigorous imprisonment. The previous convicts who were penalized, my lord, the quantum of punishment was only 2 to 8 years. And in this case, the no matters. It's not a good ground for granting bail, my lord. That's why I'm requesting to reject the previous order
It's
and allow
not
the
a
appeal.
case that the conditions imposed by the court granting bail
My lord.
has been violated by the respondents.
No, my lord.
Not the single
No, my lord.
condition.
No, my lord.
That's it.
Done?
Yes.
Lordship, I will come to the present judgment which he has read out. They were the appellant.
Yes, yes, I am.
And it was dismissed. Explaining very clear, I'll come to this, Your Honor. There are, in this 2021 judgment, in this 2021, Your Lordship, 3 judgments are there. K. Najib is 3 judges bench. And
Lord,
the
there
other
was
two-
a parameter
other
that
two
the
cases-
quantum of punishment can be only between 2 and 8 years, not more
Other
than
two
that.
cases, Your
And 5 years
Lordship.
has been spent in the jail.
Let me complete, my dear friend. Other 2 cases also decided in 2021. I have the cases of 2022 also, which relied in K. Najib case. So first of all, I will go to the full bench of the Guwahati High Court, Lordship. Lordship, page number GLT 2016, volume 4.
GLT?
GLT 2016, volume 4, page number 803.
Page?
803, Lordship. Para number 29, 30, and 31. Lordship, I will read out with your permission. I will read a bit faster to save time. Having noticed the legal position with regard to 43D, Your Lordship. Page number 812 now. Page number 812, para 29. May I, Lordship?
Yes.
Yes, Lordship. Having noticed the legal position above, provisions of 43D5 of the ULAP Act may once again be examined. It starts with expression notwithstanding anything contained in the code. In other words, it would mean notwithstanding the provisions of the CRPC. Section 43D5 of the ULAP Act would have overriding effect. In the present context, it would mean 2 things. Firstly, it would mean notwithstanding the provisions of Section 220A CRPC, Section 43D5 of the ULAP Act would have overriding effect. Secondly, it would mean that Section 43D5 of the ULAP Act would be in addition to the provisions relating to the bail contained in CRPC, such as Section 437. If that be so, there can be no manner of doubt that operation of Section 43D of the ULAP Act is an independent of Section 228 CRPC, and the latter provisions cannot control operation of the former. The referral order is right when it points out that Section 43D of the ULAP Act nowhere mandates that once charge is framed against the accused under Section 228 CRPC, the court shall presume that he has committed the offense and shall not be entitled to bail. It is tried that a penal provision has to be read and interpreted strictly. There are 30 lords. We also have to keep in mind that we are considering prayer for bail at a stage post-framing of charge. No doubt, 43D5 of the UAPA Act is a special provision which has been introduced as part of the state's response to the menace of terrorism, which is affecting large part of our country, and that its conditions are extremely stringent. Here we have to bear in mind that by specifically mentioning the words on a perusal of the case diary or the report made under Section 173 of the Code in the provision to Section 43D of the ULAP Act, the legislature has prohibited consideration of any material beyond the case diary or the report made under Section 173 CRPC for the consideration of the bail. The inevitable consequence being that any evidence laid after framing of charge would remain outside the purview of consideration of the limited purpose of granting bail. But having said so, it cannot also be overlooked that grant of bail is a discretionary power conferred upon the court. Though extremely stringent conditions are imposed while considering bail under Section 43D5 of the ULAP Act, it is one thing to say that discretion is to be exercised by the court with circumspection, having regard to the stringent natural and overall objection of the provision. But it would be an altogether different proposition to say that the court would have no discretion at all to consider bail once charge is framed. Having regard to the bail jurisdiction of a country which has evolved over the years, there cannot be a formulation of a legal proposition which says that once charge is framed, there can be no bail. Bail jurisprudence stands on a different footing altogether as a legal principle. Court cannot be denuded to the discretion to consider bail at any stage of the proceeding. It is not unusual to find that even after conviction, the appellate stage, the appellate court is not denuded of power to consider bail of the accused appellant, even though presumption of innocence of the accused appellant would no longer be available at the appellate stage. In Ridaul Hassan Khan Supra, a division bench of this court observed that no legal formula of universal application can be evolved as to when a person accused of an offense allowed to go on bail. It would be inappropriate to try to evolve an universal formula for application of discretionary jurisdiction of the court in the matter of bail. In Gurcharan Singh versus State of Delhi Administration, reported in 1978, 1 SCC 118, the Supreme Court held that there cannot be an inexorable formula in the matter of granting bail. Fact and circumstances of each case will govern the exercise of judicial discretion while considering the bail. Para 30 on here. In view of the above decision made, we are of the considered opinion that the view taken by division bench in Y. Brajabidu Singh Supra and that once charge is framed against an accused for an offense punishable under Chapter 4 and Chapter 6 of the ULAP Act, and unless the same is challenged and set aside by a Supreme Court, the accused would not be entitled to bail in view of the provision of Section 5 of 43D of the ULAP Act. Does not lay down the correct law. The view taken by Brajabidu Supra is thus overruled. As a consequence, question number 1 is answered in the negative by holding that a person accused of an offense punishable under Chapter 4 and 6 of the ULAP Act is under a detention for the same would be entitled to a consideration for bail under Section 43D of the said Act, irrespective of whether the charge is framed against the accused or not. subject to course of the limitation imposed by the said provision and having regard to the object thereof. Insofar question number 2 is concerned, it has already been answered above by holding that wide reserve the case doesn't lay down the correct law. This is the decision of the full bench of the Guwahati High Court Principal Chief Lordship. Now I am coming to SCC 2021, Volume 3, page number 723, Lordship. This is a very short judgment. SCC 2021, Volume 3, page number 723, Your Lordship. Lordship, with your permission. SCC 2021, Volume 3, page number 723. Angela Hari Sontake versus State of Maharashtra. May I, Your Lordship? This is also the cases which involves a levy charged under section 10, 13, 17, 18, 18A, 18B, 20, 21, 39, 30, 38, 39, UAPA Act, Lordship, 387, 419, 465, 468, 471, Radio 120B IPC. I will read out the relevant portion, Your Lordship. We have only 5 paragraphs. Page number 724, Lordship. Exemption from filing certified copy of the impugned judgment is granted. Permission to file additional document is granted. This is Sagar Angela Harish Santake. Leave granted. We have heard a learned counsel for the parties. Charges have been framed against the appellant accused under section 10, 13, 17, 18, 18A, 18B, 20, 21, 38, 39, and 40, subclause 2 of the Unlawful Activities Prevention Act, in short UAPA Act, amended 2008, and section 387, 419, 465, 467, 468, 471, radio section 120B of the IPC, Indian Penal Code 1860. Undoubtedly, the charges are serious, but the seriousness of the charges will have to be balanced with certain other facts like period of custody suffered, Lordship, and the likely period within which the trial can be expected to be completed. Para 3. The appellant accused has been in custody since April 2011, that is for over 5 years. Para 2, Lordship. Para 3. The appellant accused has been in custody since April 2011, that is for over 5 years. The trial is yet to commence in as much as the learned State Council has submitted that 9/5/2016 is the first date fixed for trial. There are over 200 witnesses proposed to be examined. The appellant accused is a lady. She also has been acquitted of similar charges level against her in other cases. Taking into account all the aforesaid facts, we are of the view that the appellant accused should be admitted to bail. We accordingly direct the appellant accused Angela Harish Santake be released on bail by the learned court in connection with session case number so-and-so arising out of CR number 1911 PS ATS Kalachoki, Mumbai. We also make it clear that the learned trial court will consider and impose appropriate conditions subject to which the appellant accused will be released on bail in terms of the present order, so as to ensure that the appellant accused is available for trial. In this regard, the learned public prosecutor would be at liberty to address the learned trial court so far as the conditions subject to which the appellant accused will be allowed to go on bail in terms of the present order. Consequently, in the light of the above, we allow this appeal and set aside the order of the High Court. Lordship, page number 725. This is also a very short judgment. 725. This is a Sagar Tatayaram Gorkhe and another versus State of Maharashtra. Now, page 726. I'll start from para number 2, Lordship. May I, Lordship? para number 2, Lordship. Page number 786, para number 2. May I, Lordship?
Yes, yes, go ahead.
Yes. The present application appeal for bail is on behalf of accused number 8, 10, and 11, out of a total of 15 accused. 4 accused are absconding, and of the remaining 11 accused, 8 had been released on bail by different forums, including one accused by this court by its order dated 4/5/16. The charge against the accused are undoubtedly serious. However, as observed in the earlier order of this court, order dated 4/5/2016, such charges will have to be balanced with certain other facts like period of custody suffered and the likelihood within which the trial can be expected to be completed. In our previous order dated 12/7/2016, this is talking about the Sagaram Tatyaram Gorke, Lordship. Passed in the present matter, the statement made on behalf of the state that a trial would be completed within a period of 6 months has been recorded. We are informed today that till date only one witness has been examined, and that too, his examination is also not over. The prosecution proposes to examine 147 witnesses. The appellant accused have been in custody close to 4 years. Para 4. In the above circumstances, we are of the view that the appellant accused should be granted the privilege of bail. We accordingly direct that the appellant accused be released on bail by the London Trial Court in connection with session case number so-and-so arising out of CR number so-and-so, Mumbai. We also make it clear that the London Trial Court will consider and impose appropriate conditions, subject to which the appellant accused will be released on bail in terms of the present order, so as to ensure that the appellant accused are available for trial. In this regard, public prosecutor of the state would be at liberty to appear before the learned trial court and suggest to the learned trial court such condition as may be considered fit and appropriate to be imposed, subject to which appellant accused will be allowed to go on bail in terms of the present order. This is also bail granted, Lordship. Lordship, in the same 2021, Union of India versus K.N. Najib. Para number 7.
I've already submitted.
Page number 713, Lordship. This is also page number 713, Lordship. Union of India versus K.N. Najib.
We already read.
Yes, your Lordship, I'm coming to that, my relevant paragraph also. This is also talking about 43D5, where my learned friend was now submitting with regard to 43 and 5. This is decided by the 3 judges bench of the Honorable Apex Court, Lordship. So my relevant paragraph will be para 8, 14, 15, 17, 18, and 19. With your permission, Lordship, I will insert in a hurry, I will read out. Para 8, page number 719, Lordship. Para 8, page number 719. Lordship, may I? It must be emphasized at the outset that there is a vivid distinction between parameters to be applied while considering a bail application vis-a-vis those applicable while deciding a petition for its cancellation. In Puran versus Rambilas, it was reiterated that at the time of deciding an appeal for bail, it would be necessary to record reasons, albeit without evaluating the evidence on merits. In turn, Puran cited Gurcharan Singh versus Delhi administration, wherein this court observed that bail once granted by the trial court could not be cancelled by the same court only in case of new circumstance evidence, failing which it would be necessary to approve the higher court exercising appellate jurisdiction. Para 14, Lordship. Page number 721. The fact of the instant case are more, this my learned friend has read out, but I'll read again here, Lord. The fact of the instant case are more egregious than these two above cited instances. Not only has the respondent been in jail for more than 5 years, but there are 276 witnesses left to be examined. Charges have been framed only on 27/11/20. Still further 2 opportunities were given to the were given to the appellant NIA, who has shown no inclination to screen his ended list of witnesses. It also deserves that mention that of the 13 co-accused who have been convicted, none have been given a sentence of more than 8 years, rigorous imprisonment. It can therefore be legitimately expected that if found guilty, the respondent too would receive a sentence within the same ballpark. Given the 2/3 of such incarceration is already complete, it appears that the respondent has already paid heavily for his acts of fleeing from justice. There are 15, Lordship. This court has clarified in numerous judgments that the liberty granted by Part 3 of the Constitution would cover within its protective ambit not only due process and fairness, but also access to justice and a speedy trial. In Supreme Court Legal Aid Committee representing under trial prisoners versus Union of India, which was decided in 1994, Lordship, it was held that the under trial cannot indefinitely be detained pending trial. Ideally, no person ought to suffer adverse consequences of his act unless the same is established before a neutral arbiter. However, owing to the practicalities of real life, where to secure an effective trial and to ameliorate the risks of society in a case of potential criminal is left at large pending trial, the courts are tasked with deciding whether an individual ought to be released pending trial or not. Once it is obvious that a timely trial would not be possible and the accuser suffered incarceration for a significant period of time, the court would ordinarily be obligated to enlarge them on bail. Para 17, page number 722. It is thus clear to us that the presence of the statutory restriction like section 43D5 of the UAP per se does not pose the ability of the constitutional courts to grant bail on grounds of violation of Part 3 of the Constitution. Indeed, both the restriction under a statute as well as powers exercisable under constitutional jurisdiction can well be harmonized, whereas at commencement of proceedings, the courts are expected to appreciate the legislative policy against grant of bail, but the rigors of such provision will melt down where there is no likelihood of trial being completed within a reasonable time and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of provisions like 43D5 of the UAP being used as the sole metric for denial of bail or for wholesale breach of constitutional right to speedy trial. Para 18, Lordship.
No, we've seen it. Any other?
Yes, Lordship. Lordship,
This should be sufficient.
Sorry, Lordship.
This should be sufficient.
Yes, Lordship. There are two more paragraphs. Lordship, please kindly peruse. Lordship, I have 2022, volume 1.
We already have gone through enough.
Referring to K. Najib's case, Lordship, again decided by this Honorable Court, 2022, volume 4, Lordship.
You have read the full bench order.
Yeah, that is with regard to, this is 2022, Lordship. Decided by this case, I will just give the judgment, Lordship, in order to save the precious time of the court. And this is Katoshe versus the NIA. The Honorable Division Bench of this court has dismissed the appeal, Lordship. Keeping into consideration the decision given by the Apex Court in 2021 SEC, Lordship. Lordship, I was arrested on 24th as per the NIA, Lordship. Thereafter, I was in custody for more than 5 years, 3 months, Lordship. Lordship, nothing was recovered from my possession. The seizure list prepared by the Lordship, NIA, which furnished to me. Lordship, I will request Lordship just to peruse the seizure list once. Please. Lordship, the seizure list. Lordship can see number 1, number 3, date and hours of search, 24th May 2016, 5:30 hours. Lordship will come to number 2 above, number 2, CR number and section RC4, so and so. Number 4, Lordship, name and address of person whose house is searched. Lordship, now it is clearly mentioned, Khekato, son of Itovi, resident of block number 1, Thiluki village, Dimapur, Nagaland. And from his house, Lordship, these items were seized. I was present there. I was present there for super. I didn't run up, I didn't abscond also. There were other person in the house. If these arms were recovered from the house of Khekato as per the seizure list prepared by the NIA or maybe the army personnel, the other occupant of the house should be arrested as per law. This is one, Lordship. This is, they have annexed as page number 9, Lordship. So from me, nothing was recovered. From me, not a single of these items belongs to me. Lordship, a single person who was invited for super cannot carry such a huge items. It was in the residence of this Khekato. This is one. Lordship, I will take to memorandum given by the army personnel. Lordship.
That's fine.
Fine. Okay.
Your good name, please?
NN Misra.
Heard Mr. N.N. Mishra. Learned Special PP?
Public prosecutor.
Learned Public Prosecutor. For the NIA?
Yes.
Also heard Mr.
Sharif Ahmed.
Sharif Ahmed, learned counsel appearing for the respondent, accused, within bracket A6.
Nasaka Kini.
Stop. The accused, respondent, was apprehended on 23/5/2016 from Dimapur in connection with an incident of shooting against the personnel of Assam Rifle on 26/3/2015 near Indira Gandhi Stadium, Kohima, by the members of the National Socialist Council of Nagaland, within bracket Khaplam, within bracket NSCN K. Stop. Note PS Kohima case number 0029/2015, dated 26/3/2015, was registered against the accused respondent under section 307/326 IPC, read with section 25 within bracket 1B, Arms Act. Stop. Draft, comma. The case was taken over by the NIA, and accordingly, it was re-registered as RC-4/2015/NIA/DLI against the present accused and 5 other co-accused. Stop. After completion of investigation, charge sheet was filed. When did you file the charge sheet?
It was charged under supplementary charge sheet, my lord, and it is filed on 13/6/2016.
1 minute.
Supplementary.
Charge sheet was filed on
13 June 2016.
It is supplementary charge
It
sheet.
is supplementary charge sheet.
What about the main charge sheet?
Main charge sheet.
supplementary charge sheet was filed on
13/6/2016.
13/6/2016.
13/6/2016. And the
First charge sheet was filed on 23rd November 2015.
first charge sheet was filed on
23rd November 2015.
23rd November 2015. Stop. Stop. Para. The accused respondent filed bail application before the learned special judge, NIA, which was heard and disposed of by order dated 10/8/2021, allowing bail with the following conditions. Page 32, 8 to 8. Stop. Para. Being aggrieved with the order dated 10/8/2021, granting bail to the accused oblique respondent. The investigating agency, NIA, is before this court by way of the present appeal. Stop. Para. Learned Public Prosecutor NIA submits that there is a bar for granting bail under the
43D.
unlawful activities under section 43
D, subclause D.
D.
Subclause
bracket-
5 and 6.
Within bracket 5 and 6 of the unlawful activities within bracket Prevention Act 1967. And therefore, when the learned special judge had come to the conclusion that there was a prima facie case against the accused respondent, the bail, and had granted bail. Yet has granted bail. Stop. Basically, that's the whole ground.
Yes, my lord.
Therefore, when the learned special judge and I came to the conclusion that the prima facie case, that there was a prima facie case against the accused respondent, the bail order dated
10/8/21.
10/8/21 stands vitiated in terms of the restrictions imposed under section 43D within bracket 5 and 6 of the Act of 1967. Stop. Mr.
Sharif Ahmed.
Ahmed, learned counsel for the accused respondent, on the other hand, submits that the accused has been under judicial custody for more than 5 years
3 months.
and 3 months, and till date only 8
10/8/21.
till date only 8 witnesses have been examined out of a total of
72 witnesses.
72 witnesses. Stop. Therefore, the learned special judge, taking into consideration all the facts and circumstances of the case, as well as placing reliance in the case of Where is that Nasib's case?
SCC 2021, volume 3, page number 713, Union of India versus K. Najib.
No, not this. He passed the one Supreme Court SCC one. You passed over one SCC.
I'm passing over, Lordship. 21, volume 3.
Pressing reliance in the case of Union of India versus K. Najib. Report in 2021, 3 SCC 713 has granted bail to the petition, to the accused respondent. Para. We have considered the submissions made by the learned counsel of the parties. Stop. A perusal of the materials available on record would indicate that the accused respondent was apprehended on 23/5/2016 until 10/8/2021. He was under custody,
Lordship.
which I, for about 5 years,
3 months.
Stop. It is not disputed that there are about 72 witnesses to be examined, out of which only 8 witnesses have been examined till date. Stop. Para. In the case of K. Najib, Supra, which paragraph is?
Lordship, I'm giving the main text.
No, fine, I've got 14. The Honorable Supreme Court has held a stop. Para 14, 15, 17, 18, 19. Court. Stop. Para. We have also considered the conditions imposed by the learned special judge NIA while granting bail to the accused respondent. It is not the case of the appellants that the accused respondent has violated any of the conditions. Yes. The only ground taken before us is that Section 43D, within bracket 5, within bracket 6 of the Act of 1967
Yes.
puts a bar for granting bail to the petition. Stop. However, stop. Considering the ratio laid down in the case of K.N. Najib, Supra, and also taking into consideration that the accused is cooperating with the investigating, is cooperating with the trial, is cooperating and appearing before the trial court.
Yes.
Stop. And that he has not violated any of the conditions laid by the special judge in I, we are unable to agree with the learned counsel for the applicant for dismissing the bail for setting aside the order dated
10/8/21.
2021 passed by the special judge NIA in IA. Is it IA
126.
criminal 196?
Yes, Lordship.
196 of 2021. Stop. Accordingly, the present appeal is dismissed.
Obliged, Lordship. Obliged, Lordship.
May I please, my lord? Yes, I beg to mention IN number 165 of 2022. Your lordship, it was not listed today, but this item was supposed to be listed on 12th. That is Monday, your lordship. And there's an interim order operating operating against me. So, your lordship, kindly list this matter tomorrow, your lordship. Obliged.
You submit your mention.
For motion, item number 1.
May it please
Yes,
your lordship.
please.
Lordship, here the petitioner is seeking for is a work charge retired work charge employee seeking for regularization.
Yes, who appears? What, MS?
Mika lordship, Mika HIA lordship.
Mika HI.
Lordship.
Learned counsel for the petitioner. Issue notice. Mr.
Vivero.
Vivero and the government advocate enters appearance and accepts notice on behalf of all the respondents.
Yes, lordship.
On behalf of all the respondents. Notice on respondents are complete. Respondents are notified contract. List title for weeks.
Obliged. Lordship, these are all similar matters,
Item
lordship.
2 and 3, same orders.
Much obliged, lordship.
For admission, item number 4.
May I please, your lordship? Lordship, I beg, I may bring on behalf of Ma'am Lucy. Lordship, I kindly list this matter on 24th January.
Who appears?
Yes, my lord, I'm mentioning on behalf of the council for the respondent number 6.
Who's respondent number 6?
Accountant General.
On request made on behalf of MS Lucy Leonard, Senior Government Advocate, list the matter on 24th January 2023.
For admission, item number 5.
My pleasure, lordship. I may bearing on behalf of V. Zino. Lordship, may kindly list this matter after vacation. He is yet to file counter affidavit.
On request made on behalf of Mr. V. Zimal and the Government Advocate, 3 weeks' time is allowed to file counter affidavit. List after winter vacation.
Much obliged.
For admission, item number 6.
May it please, Your Lordship. Lordship, this matter relates to posthumous regularization. Lordship petition, annexure A, page 15. Lordship, petitioner deceased husband was appointed initially in the year 2000, in the year 1983, Lordship, as work-touch mason helper. Lordship, thereafter he was given a promotion. Lordship, annexure B, page 17. In the year 1991, Lordship,
Promotion as Mason.
yes, Lordship, Mason. So, Lordship, following his appointment, his service book was open like any other regular employee, and his annual increment was also granted, Lordship. And while he was in active service, the petitioner's husband was expired in the year 2010, Lordship. Lordship, thereafter, the petitioner,
When did he die?
21/2010. Lordship, thereafter, the petitioner has filed his representation on 2 occasions. Lordship, in the year 2010, right after the petitioner deceased husband expired, that is 6/5/2010, and again on 11/12/2019. That was her last representation, Lordship. In spite of that, her representation has not been disposed of, Lordship. And Lordship, this similarly situated person, this is a covered case. I have annexure Annexure H, Annexure H, and Annexure F. Lordship, similarly situated person from the same department who are junior to the petitioner deceased husband were given regularized by the state respondents. Lordship, Lordship may kindly pass similar order.
Yes, Mary.
Lordship, all in all, the prayer of the petitioner is for posthumous regularization. Against this, Your Lordship, the state has preferred an appeal before the Supreme Court, and the judgment of the division bench as well as the single bench has been set aside, Your Lordship. So, Your Lordship, I may be allowed to, basing on this, Your Lordship, in view of this, the present repetition cannot sustain, Your Lordship.
Lordship, that is not my case. Lordship?
No, Your Lordship, the petitioner expired in 2010, Your Lordship. So
Lordship,
before
but-
his expiry, he never make a representation before the authority also. So it's all in all posthumous
But in that case,
regularization.
Lordship, she slipped over her rights. She didn't claim, she didn't submit her representation for 12 years. Whereas in my case, I have submitted my representation twice. Lordship, in the year 2010 and 19. And similarly situated person who are much more junior to the petitioner were given regularized posthumously. Lordship,
By order dated?
Lordship, may kindly turn to Annexure G, page 30. This is the judgment and order passed by this Honorable High Court, and Annexure K, page 36. This is the order where the petitioner's husband was regularized, Lordship. That was 6 June 2017.
Or you can consider the representation in this proceeding.
Your Lordship, in fact, we have already filed our affidavit also.
In your affidavit that have you got a copy of the judgment of the Supreme Court?
Lordship, I have.
Where is the judgment? Is it the judgment of Emarcha?
State of Nagaland and
No.
another versus
Judgment passed by Justice Emarcha.
Yes, Your Lordship, yes.
What was his seniority when he died? Seniority of the petitioner's husband?
Petitioners, Your Lordship, that I have not obtained instructions regarding.
Get the get the seniority list.
Lordship.
See, one thing is this, in this particular judgment,
Lordship.
one thing is what you are saying is correct. The petitioner never applied for regularization. Wife applied after 12 years or 16 years.
Yes, there is.
In this case, that is not the issue. Now, the other issue is that petitioner is not, was not within the senior, there were other senior work employees.
Yes,
above the
yes.
petitioner. So let us have a look whether the at the time when the petitioner died,
Lordship,
whether there were any other workers
senior to him.
senior to him, and then
Lordship.
he passed away.
Lordship, Lordship.
Right? But Mr. S. Longman, MSS Longman, and the counsel for the petitioner. MSS Mary shall produce the seniority list of work charge mason
Mason,
under the Department of
BWT.
Public Works Department,
Lordship. Kiferi Division.
under the work charge under the Public Works Department.
Housing.
Housing. Prior to the date of the petitioner's late husband. How much time will you require?
After vacation, Your Lordship.
Please stop the vacation.
For admission, item number 7.
Yes. Any instructions?
Yes, Lordship. Since the resolution is still pending before the authority, so Lordship please to dispose strictly in terms of the office memorandum 17
Heard
September
Mr.
2015
Alamabang, let me counter for petitioner.
and 18 June 9 April 19.
Also heard MS, your good name was
Bijano Gitan.
Bijano Ketan, Learned Counsel, Learned Government Advocate, appearing on behalf of the state respondents. Stop.
My lord, my prayer will be to consider my appointment in Group C and within a stipulated period of time, because I have computer education as well as pass my class 12.
Your father was working as?
Mason, grateful. However, under the scheme, I can be considered under Group C as per my qualification.
Law is settled on this. You can't get a work, you can't get a job above the work, the job your father was holding. The father of the petitioner was appointed as a work charge semi-skilled Jukali on 5/5/1986. Drafted by office order dated 20 April 2001. The petitioner's father was observed as work charge mechanic grade 2. Correct?
No, my lord, Mason, grade 4. Stone crusher operator, retired.
There's a work charge.
No, my lord, regular employee.
Where's your regularization order?
In annexure, my lord. Please go to annexure P, my lord, page number 13. Page number 13.
As handyman.
Yes, my lord.
Was observed as a handyman in the scale pay of rupees 2610-3540 per month. Stop.
And thereafter, he was transferred as a stone crusher and annexed C, page number 14.
By another order dated 18/10/2001, the father of the petitioner was transferred to Aboy against stone crusher number 921. Stop. While the petitioner's father was serving as such, comma, he died in harness on 19/6/2015. Stop. As the petitioner's family was facing great hardship after the demise of his father, comma, he made an application for appointment on compassionate grounds. He made applications for
Yes, my lord.
appointment on compassionate grounds on 1/9/2021, 2/6/2022, and 27/9/2022. Stop. However, comma, all the three applications are yet to be considered by the concerned authority. Stop. Where are you 1/9/22? Made a application before the chief engineer, PWD, mechanical, correct? Nagaland, Kohima. Stop. MS Pichanu Kitan,
Yes, Lordship.
learned government advocate, submits that the present petition may be disposed of, directing the chief engineer, PWD mechanical, oblique respondent number 3, to consider and dispose of the applications made by the petitioner in terms of the office memorandum dated 17 September 2015.
Yes, ma'am.
And addendum dated 9th April 2019, both issued by the Personnel and Administrative Reforms Department, within bracket Administrative Reforms Branch, Government of Nagaland. Stop. Para. Accordingly, comma, on consensus, comma, this writ petition is disposed of, directing the respondent number 3 to consider the representation made, to consider the application made by the petitioner for appointment on compassionate grounds on 1/9/2021, 2/6/2022, and 27/9/2022, strictly in terms of the office memorandum dated 17 September 2015 and addendum dated 9th April 2019, within a period of 3 months.
Yes, Lordship.
3 months from the date of receipt of a copy of the order of this court, with the aforesaid observations and directions, writ petitions disposed.
Much obliged.
Let my lord.